So the rebirth of OSP's office, kisi eja ben ene abusu ho aba be press conference and the press conference aba be no wato eja ene de ato NPP headquarters abom ena esi ebo so na the press conference no NPP for no more tete ehwe no mo wi omo ho hwe no na ensema OSP kisi eja ben kan no anye omo de abusu ha mo be ka ya se u follow platform we e follow ni ya ba eba be breaking news bi ema the Attorney General versus OSP prosecutorial power bi the Attorney General ediko PM court all ka say OSP any power bi ase ese or the prosecute and abusuya case no ko PM court case no ko PM court no OSP cases are ordinary no ye the injunction eto so na case no ye di wi no court ne san so e grante OSP power say obetumi aye ne prosecution na we ena OSP kisi ejaben ababaya press conference aka said the rebirth of OSP's kisi ejaben ne office na sa office no Ghana for bebre omore every sa office no o se Ghana for enka omonka omakoma den ento omoyem na sisi anom sa prosecutions ewo ho be or babaya prosecutions say freeze account ye be freeze say ye seize o property ye be seize say oko jailer enya dia ode ho becha even kra no ne bakra ne wa na oye NPP ne a ode obekwa akotum abusua na we na NPP for ne te assembly say hey OSP nso de ne twotwomutwo ene NPP for no eba evidence ne fact criminal appointees na nioma ekura OSP no o say enya de a ode obi an ho ebeche no na court no from nya after say legal vacation no omo beba no cases a OSP ni so ode ba be gu from no ebe Ghana na bia anwa abusua na we ena ne nsem a all ka no mo be kan a o san so follow platform we ya ye be breaking news bi mamo Oscar bribery and corruption cases bi a so US are involved with Ghana ye parliamentary MPs ne bi sa $1 million bribe ye course abusua OSP say ono ene di mu ntintiman a se ema sa one man ya oye involved in $1 million scandal yi abusua ono ene se odi mu akotene one FBI US omo na yes ade na sa dual citizenship ya na akwayi kure or the boss akro no cases ni na ye no nti Ghana for enka omo akoma ento omo yem na right now no NPP for no omo aso ayehye ewo OSP ni side or the pressure bi ato omo so yenko na yenko ti enseme course ba ye de aka ato omo so unsubscribe ya subscribe answer na be ko Ghana ha say open computer papa and a laptop papa na we use abura perosi computers and accessories say ho and na obenya laptop papa na we use the location enye ira kwan o Kumasi Buokrom Estate A pick number no ne friend no yedamase.
The OSP considers such civic vigilance essential to safeguarding Ghana's anti-corruption architecture, institutional independence, and the rule of law. We also salute the legal team of the Amici Courier. Every page of your legal brief was a delight and an eye-opener, and this is coming from a law lecturer. The Supreme Court decision should be celebrated. It has set matters clear as to the functions and operations of the OSP and the coexistent relationship between the Attorney General and the OSP. It has greatly strengthened the fight against corruption, and it is upon the decision of the Supreme Court that I declare a rebirth of the OSP. We will show no fear or favor. We will remain resolute in the lawful discharge of our mandate. We will rigorously investigate cases. We will vigorously prosecute cases where the evidence indicates wrongdoing. We will actively recover assets. We will take all necessary steps to prevent corruption. This is our mandate. Recognizing that the fight against corruption will persistently be heckled by the pushback of corrupt actors, we have championed and we will continue to champion that the powers of anti-corruption agencies should be enlarged and enhanced, especially in respect of two main indices. First, global anti-corruption best practices indicate that broad-based lifestyle audit, non-conviction-based asset recovery represents the fairest and optimal method of frontally addressing corruption and unexplained wealth. Therefore, we have championed and will continue to champion that institutions like the OSP and the Economic and Organized Crime Office, (EOCO), should be invested with express and effective lifestyle audit, non-conviction-based asset recovery powers to assure that persons show legitimate sources of income sufficient to justify their ownership of property. Therefore, where a person's resources far outstrip his legitimate income, the unexplained portion should be liable to confiscation. This will also be a critical tool to detect fraud and undeclared income for tax purposes. Added to this, conviction after criminal proceedings should not be a condition precedent for asset recovery. Civil proceedings should suffice. Second, we have championed and we will continue to champion the institution of a reverse onus clause of a presumption of corruption tied to lifestyle audit. Therefore, where a person is in possession of property disproportionate to his known legitimate sources of income, he should be deemed to have obtained it through corrupt means unless he proves the contrary. This proposed unexplained wealth mechanism is not a shortcut around justice or a license for arbitrary confiscation. On the contrary, once the appropriate legal threshold is established before a civil court, unreconcilable assets not traced to legitimate sources of income should be liable to confiscation. Even though our investigative and prosecutorial work was gravely hampered after 15 April, we have not been indolent. We have reviewed all cases under investigation and at trial. In some cases, we have uncovered more evidence of wrongdoing. In other cases, we have identified more suspects. We are going to refile some of the pending major cases based on our discoveries. The nature of the cases the OSP handles are extraordinarily complex, and it is acknowledged globally that corruption cases are among the most difficult to prove. These cases cannot be judged simply by how swiftly an arrest is announced or prosecution is commenced and concluded. They require immense time, painstaking mining of credible information, forensic analysis, adequate resources, and cooperation across jurisdictions. And so, on 6 August 2026, a federal jury in Brooklyn, New York, convicted Asante Kwekubeku, a dual citizen of Ghana and the United States, and former managing director of Tema Oil Refinery, and former executive director in the investment banking division of the US-based Goldman Sachs Group, of conspiring to pay more than $1 million in bribes between 2014 and 2015 to multiple Ghanaian officials in connection with the development and financing of a 370 megawatt fuel oil plant in Tema, Ghana, under a deal between the Republic of Ghana and Aksa Energy Üretim, a Turkish energy company and a Goldman Sachs client. The OSP provided investigation and evidentiary assistance to the Federal Bureau of Investigation, FBI, of the United States through Ghana's established mutual legal assistance framework. The involvement of the OSP has been acknowledged by the United States Department of Justice, DOJ, as providing significant assistance to the prosecution. Even with this, people say, we claim it is always the OSP. The conviction underscores the importance of international cooperation in the investigation and prosecution of complex corrupt acts spanning multiple jurisdictions. Predictably, the outcome of the trial of Beku in the United States ignited immense public interest and discourse on the domestic dimension of the investigation in Ghana. We wish to state clearly that the OSP's work on the matter did not end with the assistance provided to the authorities in the United States. We have been actively and carefully investigating the Ghanaian dimension. I say carefully because it must always be borne in mind that a conviction of a person in a foreign jurisdiction does not, of itself and without more, establish criminal liability under Ghanaian law or justify the immediate prosecution of other persons in Ghana connected with the underlying conduct. Each person's act must be assessed under Ghanaian law, using lawfully obtained evidence capable of supporting a prosecution here. The nature of the evidence and the applicable law determine whether prosecution should be commenced in Ghana or otherwise. That is to say, the conviction of Asante Kwekubeku in the United States does not provide automatic basis for the prosecution of identified persons who acted with him under Ghanaian law. The circumstances of the case are such that the actions of Beku may not necessarily establish culpability in other persons under Ghanaian law. The OSP will not prosecute a person solely on the basis that a person's name appears in proceedings conducted in another country. Equally, the OSP will not hesitate to prosecute such persons where the evidence establishes a proper basis for so proceeding. As I stated earlier, we have been carefully investigating the Ghana dimension, and our public silence has not meant inaction. Our involvement with the case and the evidence so far enable us to identify the following as the main persons of interest in this case. 1. Kwabena Donko, who was at all times the Minister of Power. 2. Francis Walkson Kwesi Jata, at all times the technical advisor to the Minister of Power. 3. Solomon Ajete Sowa, at all times a deputy director at the Ministry of Power. Lyndon George Nisor Metal, at all times a director at Tricop Group Limited. And Bafo Ankuma Brobe, at all times an employee at Tricop Group Limited. These are our persons, our main persons of interest for the time being. Other persons of interest include some present and former employees of Volta River Authority, Ghana Great Company Limited, Electricity Company of Ghana, Public Utilities and Regulatory Commission, and some staff of the entity formerly known as the Ministry of Power. Please bear in mind, and this point should be strongly emphasized, that the person of interest is not necessarily a suspect. The two categories, person of interest and suspect, are distinct investigative classifications and should not be treated as interchangeable. Then again, identification in either category does not constitute criminal culpability or conviction until guilt is proved beyond reasonable doubt to the satisfaction of a court of competent jurisdiction. So, we should be circumspect as to how we report this announcement and how we treat the named persons of interest. Still on this case, we have heard talk and from official sources that the OSP should not be the institution investigating the matter, and that the OSP lacks the capability and track record to investigate the matter. This begs the obvious. The institution, which provided significant assistance to the successful prosecution of Beku in the United States, rather lacks the capability and track record to investigate the Ghana dimension, and that other institutions, which were not even involved in the matter, are more competent than the OSP. Once again, Uchiro Kwadua, now we're in America. We did the case with the FBI, and you are saying we are not competent to handle the case. What kind of logic is that? At the OSP, we do not regard the fight against corruption as a competition between institutions and as pitching one public agency against the other. At the OSP, we reckon that the anti-corruption drive is better served through cooperation and collaboration among public institutions. History teaches us that where investigative and intelligence agencies compete among themselves and fail to cooperate with each other, unhappy events ensue, as was the case with the infamous events of 11 September 2001 in the United States. We call on our sister investigative, intelligence, and prosecutorial institutions. Let us cooperate with each other. Let us collaborate. Let us share intelligence. Let us compare notes. Let us work together. It is one Republic of Ghana, just one. So let us make her great and strong. Thank you for coming, ladies and
today's conference.
Well, Kemeni, thank you very much. And so it was a very brief one and very straight to the point with no questions. But the Office of the Special Prosecutor started this press conference seeking to reiterate in some detail the work that they've been able to do as an office in the lead up to that very famous suit, which was determined by the Supreme Court some weeks ago, right? And so, of the many things, the special prosecutor Kise Jabe mentioned that up to 7 convictions have been secured. Then he went in on the suit, which was taken to the Supreme Court by private legal practitioner Noah Damte. And interesting revelations he makes in relation to that, starting first off from the fact that when that suit went in, they at the Office of the Special Prosecutor picked intelligence to suggest that the Attorney General's office was not going to defend the suit or defend their position in law with respect to what they believe to be an independence and a free will to, amongst many other things, prosecute and deal effectively with graft and its related matters. In fact, he makes argument inference to suggest that the entire act which established the office was essentially under threat by virtue of that singular suit which had been taken to the Supreme Court by Noah Damte. Reason for which, upon that intelligence, they proceeded forthwith to join the suit, but the Supreme Court, or the justices of the Supreme Court, declined in allowing them be parties to the suit. And he makes a very poignant statement in that case to suggest that they did it anyways for posterity to remember and judge that when it mattered, they took some course of action in relation to it. And so that already would have laid a premise as to where all of this was going with respect to what they see, what they feel in terms of their operations as an investigative arm looking into acts of corruption. Then he singled out as well the respective civil society groupings who went to the Supreme Court as friends of the court, seeking to aid the court in arriving at a decision and in putting arguments before the court. They were allowed to be parties to the suit and mention them one after the other, the respective civil societies, and acknowledge them for a great job done in helping to keep the office alive. In fact, when all was said and done, he made these following statements: that the Office of the Special Prosecutor has been reborn. It's been given a new lease of life by that decision of the Supreme Court, and it gives them the impetus and the verve to move forward in dealing effectively with graft. Says that they will take no prisoners in their quest to ensure that graft is reduced to the barest of minimum, and the task of prevention becomes the go-to. That was pretty much the foundation laid up before we went into the AXA conversation as well, because that's come up strongly in the last few weeks as well in relation to some agreements which were entered into by the government of Ghana and then AXA Energy to procure a power barge in the very early days of the debilitating power crisis which hits this country from about 2014 all the way to the 2016 elections. He said that they, being the Office of the Special Prosecutor, played a very important role in assisting the Federal Bureau of Investigations, the FBI, in arriving and being able to put before a U.S. court concrete arguments which resulted in convictions of Asante Beku and some other persons, and says that that effective work was acknowledged by the Department of Justice of the United States when they were giving out thanks to agencies and respective bodies which aided in helping to have the work done. Now, from there, he proceeded to name some names in relation to persons of interest, because he sought to, amongst many other things, do two things: speak to the convictions in the U.S. and the expectation, right, as to what that means within the Ghanaian jurisdiction with that having happened. Now, he laid the premise to start off with that a conviction in the U.S. does not automatically suffice to, amongst many other things, arrive at a decision that persons who were subject matter of that investigation are automatically presumed guilty as well. And he used the word careful investigations. Careful investigations to suggest that they are seeking to look through the body of evidence vis-a-vis the respective laws in the jurisdiction to arrive at a conclusion as to whether or not these persons of interest will become subject of investigation and subsequently subject as well of prosecution, right? Subject of prosecution. And so he put forward some names, and the caveat he provided after providing the names was that these are persons of interest and are not automatically persons who are presumed guilty in the sense of the word. And so who are these individuals? Well, you, Kemeni, would have spoken to lawyers of one of such persons, and that's the former power minister at the time when these negotiations were put together and an agreement was reached with AXA Energy. Kwamna Donko, who was at the time the power minister, is a person of interest, according to the Office of the Special Prosecutor, with respect to these investigations which will go forward. Then there is one Francis Walkson Kwesi-Jatta, who was closely associated with the power minister at the time. There is Solomon Ajete Soa as well. There's Lyndon Myrtle, Bafor Ankoma Brobe. These are the names which were forthrightly given. And then he mentions that there are some other persons who are of interest as well, being present and past staff of the Ghana Grid Company, the Volta River Authority, and an electricity company of Ghana, amongst a few to mention, who will also be persons of a subject of interest. Then he closed that the address with what has become commentary surrounding the development around the AXA deal after it broke, the conversations amongst who should lead the investigations, who should be trusted with investigating our part of the development in the US. And he paid attention or gave mention to what he described as official communication as well, to suggest that the Office of the Special Prosecutor may not perhaps bear the requisite competencies to look into the matter. Then he asks a question. The agency responsible cardinally for assisting the FBI in arriving at convictions not being credible enough, he questioned that logic and said, amongst many other things, that what he will advise is that, look, in going forward, there is just one republic, which is the Republic of Ghana, and that investigative bodies should be working collaboratively. They should be comparing notes and seeking to fight grafts together, and not be in a competition of some sort as to who emerges victorious in being able to investigate a subject matter or not. And so that is, to put into summation, what the Special Prosecutor Kissie Jabe has been sharing with the people of Ghana. He stated he wasn't taking questions, and so he left it as that. Kemeni.
Thank you very much for the summary. I appreciate your time there and with us here. But as we continue this coverage of the very important information the the Special Prosecutor Kissie Jabe has shared with us now, I just want to go over again what has happened so far. So the Special Prosecutor has been defending his performance. He's also talked about the strained relationship stemming from the April 15th suit between or among law enforcement agencies and the Attorney General's office specifically. But he's also, leveled it down to the AXA Energy issues leading to the conviction of Beko in the US and how it relates to, entities here in Ghana. I want to bring him now, Edem Senanu, who is an anti-graft campaigner. Let's talk about what we've heard from the OSP so far. Well, my understanding is that we do not have Edem Senanu at this point, but the OSP has talked about a number of things. And I want to start off again with the AXA Energy persons of interest in Ghana. Dr. Kwabena Donko, the former power minister, Francis Walkson Kwesi-Jatta, who is a technical advisor at the time of the power ministry or the power minister, Solomon Ajete Soa, a deputy director also at the power ministry, two staff of Tricor, and then the OSP also says there are other persons of interest, past and present staff of the VRA, Gridco, ECG, PURC, and the now non-existent power ministry as well. Then it goes back to the document we've seen already. These will appear to also be drawn from that document we have seen, the indictment we saw on Bekom. But I'll bring in now legal practitioner Alhaji Inusa Fuseni. Alhaji, thank you very much for your time. You heard the OSP. Perhaps the most poignant will be the AXA Energy and the investigations the OSP will do into the Ghana dimension of this. How crucial are the names that we know now that have come up?
Well, thank you for having me. The names seems to indicate those who were directly connected with the AXA project. They are of interest because of the level of their involvement in the project and the presumption of complicity that their involvement raises. So it is not as if to suggest that they are culpable or they are suspect, but the OSP will want to understand and appreciate the level of their involvement and whether or not, while pursuing the project, they did anything illegal.
But what should we do with the names now? When you read the U.S. indictment, we had an idea of who may have been involved in this. So for the OSP to organize a news conference and name names, what for? What do you think this was for?
This is an investigation. That's the starting point of our investigation. People have been identified to have been connected with the project. And that being so, they ought to investigate to know the level of their involvement and whether or not their involvement and participation occasioned some wrongdoing for a prima facie case to be raised against them. And so, yes, the American authorities indicated that some persons connected with the project did certain things that were not permissible or allowable within the context of American jurisdiction. And so they have found the person who was the lead person guilty of that offense. They found him guilty because his activities contravened the Foreign Practices Act, Foreign Corrupt Practices Act. And so he was the subject of interest to American people and all persons who were of American nationality, who had conducted themselves in such a way as to bring themselves within the context of the law. Now, for us, and so they were not interested in the Ghanaian people because their jurisdiction did not stretch to the Ghanaian people. And so we are not taking up the matter. And they redacted the names. They redacted the names. The report doesn't include names of those people. It gives indication of those, who those people might be, but no names. Now, so the the Office of the Special Prosecutor is now digging deeper to understand the role of the various persons, the role that various persons played in the construction process, and whether or not some of them were, had conducted themselves in such a way as to bring themselves within the jurisdiction of the OSP.
Let's bring in Nanu. He's an anti-graft campaigner on this conversation or coverage of the OSP's naming of persons of interest from the AXA Energy scandal, as we have come to know it. Adam, good evening to you. Thank you so much for your time. But for you as an anti-graft campaigner, this must be good progress on the Ghana dimension to the case, isn't it?
Well, yes, it's good, especially when they say they have continued the investigations beyond the conviction that the U.S. courts announced a few weeks ago, and that they are likely to get back to us on these developments. I think that is comforting because we're all wondering, is that the end of the story? Mm-hmm. So yes, definitely good news that the office has given us.
I see. Let's look at the names. Dr. Kwabena Donko, Francis Roxon Kwesi Jata, Francis Walson Kwesi Jata, Solomon Ajete-Sowa. These were both directors at the Ministry of Power. Kwesi Jata being a technical advisor, Solomon Ajete being a deputy director at the Ministry of Power. You go down, we see 2 staff of Tricor as well. Would you have loved to hear a bit more on what progress the OSP has made, other than giving us the redacted names from the U.S. indictment? Wouldn't it have been a better, I do not want to say use of time, but wouldn't it have been a better communication to the Ghanaian people on the progress of the case?
Well, only to the extent that that would not compromise the ability to go to a court of competent jurisdiction and get a conviction. And I guess that striking the fine balance between that and giving information to the people of Ghana is one of the challenges that they will face. And that is evident in how much they were willing to give today. So I think that they are the experts, and they probably wanted to be cautious. They were probably indicating that, look, we have more information. So if you've seen some from the U.S. court, there's additional we have. We are following up on that. I think that the assurance that at some point they would be able to get to a position where they can give further and better particulars should be sufficient for now, just so that they don't end up, losing cases that it is simply because they provided too much information at a point where they ought not to have.
So abusuya we ne ensema course so political highway so OSP kisi ejaben ena yete ne nka se odesa ensem no tudwa ede amaya ye bedama se samo JP ne kokoti sa ensem we ede mai aha gossip politics TV so